American poet Carl Sandburg once wisely said, if the law is against you, argue the facts. If the facts are against you, argue the law. And if the law and the facts are against you,
pound the table and yell like hell.
Gleason is pounding the table and yelling like hell. Michael Flynn is pounding the facts and the law. Viva Fry, Montreal litigator turned YouTuber. It's another kid sleeping in the back, so it's another afternoon car vlog, and there are updates in the Michael Flynn judicial saga. No 30,000-foot overview of the subject matter. I am taking for granted that if you're watching this video, you have at least a base knowledge of the subject, but if you do want to bone up on all of the Michael Flynn judicial saga, I'll make a playlist and link it right here. Give it a watch when you have, I don't know, an hour and a half. The last vlog I did on the subject was breaking down Judge Gleason's amicus brief in opposition to the Department of Justice's motion to dismiss the criminal information against Michael Flynn. If you haven't seen that vlog, I'm going to link it right here. Give it a watch. It's a good one.
They're all good.
In that breakdown, I explained that the amicus brief seemed to have been filed somewhat prematurely, or at the very least in advance of the arguments presented before the Court of Appeal on Michael Flynn's petition for writ of mandamus. And I stand by that assertion. That amicus brief was filed, if not to influence the Court of Appeal, at the very least the Court of Public Opinion, because that was written for public consumption. Gleason filed his amicus. Arguments were made before the Court of Appeal on June 12th as relates to the petition for writ of mandamus, and on June 17th, Michael Flynn filed his opposition to the amicus. On June 17th, Flynn filed his opposition to the amicus, and we're going to break that down right now after I put the kid in the house. You don't want to listen to Michael Flynn's opposition to the amicus?
No.
I'll be back. All right, I am back, and hopefully all of you are actually interested in going through this brief. Now, I'm not going to go through the brief in opposition to the amicus in great detail, but suffice to say, Michael Flynn is pounding the facts and the law, and he is pounding them hard. General Flynn's brief in opposition to amicus. Counsel for General Michael Flynn files this brief to comply with this court's order of May 19, 2020. However, we hereby preserve all objections briefed in our petition for writ of mandamus and all prior filings in this court. This court exceeded its authority under the Constitution to solicit amici and to appoint an amicus. That chosen amicus has now engaged in a flagrant, personal, and partisan assault on General Flynn, Attorney General Barr, and the President of the United States. I already would not want to be in Gleason's shoes. Now, I know there are a lot of people out there who are going to accuse me of having a bias, which is coloring the way I view this file, and to them I would say there is a difference between having an opinion and having a bias. An opinion is a conclusion that is derived from observations of fact. A bias is a tainted way of viewing those facts that otherwise taints your opinion. The two concepts are not interchangeable. Having an opinion is not necessarily the same thing as having a bias, although having a bias will taint your opinion. I have an opinion in this file, and that opinion is that Michael Flynn was done dirty, but that opinion is a conclusion drawn from an observation of the facts. And those facts are fleshed out in even greater detail in this brief than they were in the Department of Justice's motion to dismiss. All right, and I don't know how I did this, but I forgot to read perhaps the most important paragraph of the brief. If it's not the most important paragraph, it might be the most powerful paragraph. So I'm inside just editing this video together, so just let me add that. The irony and sheer duplicity of Amicus's accusation against the Justice Department now, which is finally exposing the truth, is stunning. Amicus's filing is a, quote, wrap-up smear. It is an affront to the rule of law and a raging insult to the citizens of this country who see the abject corruption of this assassination by political prosecution of General Flynn. This court exuviated any appearance of neutrality when it unlawfully appointed Amicus as its own adversary to make these scurrilous arguments. And after I flash screenshots of the definition of exuviated and scurrilous, I'm gonna get back to the video. This court must grant the government's motion to dismiss with prejudice to which General Flynn has consented. This court is foreclosed by all relevant precedent from going behind the current record on the government's motion to dismiss. Fundamental principles of separation of powers foreclose any such inquiry. Waite versus United States, discretion to prosecute is particularly ill-suited to judicial review. Moreover, upon the government's motion to dismiss and General Flynn's consent, there is no case or controversy which the court can continue to act other than to grant dismissal. The concept is that there is no case or controversy between the parties. There's no dispute. The judge has nothing to do except for granting the Department of Justice's motion to dismiss. And I know some of you are saying to yourselves, as you should, well, the dismissal requires leave of the court. It requires permission of the court. That is true. And Flynn addresses that point in the next paragraph. In granting the leave, the court is authorized to review the record as it exists. It is not allowed to create a new record. While the court may review the existing record on the government's motion to dismiss, it may not create a new one. Not a single case authorizes an Article 3 court to scrutinize the decision-making process of the Department of Justice in deciding to correct itself and move to dismiss a prosecution that should never have been brought. And what is an Article 3 court? And before Flynn gets into pounding on the facts, they go ahead and pound a little on the law. Further, just 1 year ago in May 2019, this court granted the government's Rule 48A motion to dismiss an indictment, adding with prejudice due to numerous errors by the government and in light of the, quote, unusual and indeed disturbing facts of the case. The rules have not changed since this court correctly applied them there. Flynn then goes on to distinguish from some of the jurisprudence that Gleeson cited in the Amicus Brief, but I don't think we need to get into that tedious exercise. I will flash a screenshot of that text if you want to go ahead and read for your own education, but let's get back to some more law. Preservation of the separation of powers is paramount. This court, in essence, appointed its own special prosecutor, adversarial to the Attorney General and the defendant, to extend the prosecution of General Flynn and to consider and suggest further charges or punishment be used against him. This process was tried previously and ultimately resoundingly rejected. In 1978, Congress passed the Ethics in Government Act that included an independent prosecutor who worked outside the control of the Attorney General and reported to Congress. That rule sparked the famous Morrison versus Olson litigation, in which the Supreme Court incorrectly held that the office of the independent counsel was constitutional. Full disclosure, I have not read that decision. I do not intend on reading that decision, but from what I understand, Justice Scalia, who was the dissenting opinion in that decision, was later proven to be correct. Justice Scalia was proven to be correct. The tortious and constitutionally damaging experiment came to an end with the unanimous agreement of Congress and the Justice Department that the statute was indeed a violation of the separation of powers. Now, I read through Gleeson's Amicus Brief, and I agree with the passage I'm about to read, not because of bias, but because it's a conclusion that I came to after having read the evidence. This politically motivated quest to destroy General Flynn has been damaging the rule of law, the integrity of venerable institutions of government, and now the very structure of our Constitution. This illegal outrage must stop now. Now, that may seem a little dramatic depending on who you ask, but one thing is clear from reading Gleeson's Amicus Brief. It was a political brief, pure and simple. It used hyperbolic and inflammatory rhetoric, it relied on certain facts and ignored the bad facts altogether, and like we say in law, you cannot get away with ignoring the bad facts, period. You have to recognize them, you have to respond to them, and you are better off doing it before your adversary does, because if they do it before you, they're going to rub your face in it hard, and that is pretty much what happens in this brief. The court had no authority to appoint Gleeson, there is no case or controversy, and this court cannot usurp or even inquire behind a core executive function. The government's motion to dismiss ended the case and controversy before this court. It has no authority to proceed beyond granting the dismissal. U.S. Constitution, Article 3, Section 2. The game is over. The government has left the field. This court must leave the field also. The unanimous decision of the Supreme Court only weeks ago establishes that an Article 3 judge cannot create issues for the parties or gin up his own case or controversy where none exists. Sinning Smith, there the court wrote, courts are essentially passive instruments of government. They do not or should not sally forth each day looking for wrongs to right. They wait for cases to come to them, and when cases arise, courts normally decide only questions presented by the parties. We talked about Sinning Smith in previous vlogs, and that seems pretty clear cut, but it gets even worse for Sullivan and the court. It is an entirely separate violation for the court to enlist amici in a criminal case, as counsel for General Flynn briefed immediately before and after the court invited their participation. Even more important, the court cannot appoint an amicus in a criminal case to proceed against a defendant. It has no authority to appoint anyone to step into the place of the government in a criminal prosecution. And I don't generally read the footnotes, but this one is just too beautiful and powerful to ignore. Footnote 4. The choice of this particular amicus to appear against the government and the defense is appalling. As counsel for respondent admitted in oral argument in the D.C. Circuit, Gleeson was assigned by the court to be the adversary to the government and General Flynn, to take over the role of the government in violation of the executive's core function in Article 2. Gleeson advertised his bias to obtain the appointment. John Gleeson, David O'Neill, and Marshall Miller, the Flynn case isn't over until the judge says it's over. Washington Post, May 11, 2011. It is not biased to say that someone like Gleeson, having written things that Gleeson had written, had no business being the amicus in this file. It is not a question of bias, it is a question of judgment. An amicus is supposed to be a friend of the court. They are not supposed to be the agent of the court. This court must grant dismissal on the existing record. Given the substantial briefing and documentation by the Justice Department of the reasons for dismissal here, based primarily on the government's proper recognition that it should correct its own misconduct, which included suppression of extraordinary exculpatory evidence, this court has no further role to play than to grant dismissal forthwith. And then to pound on the law for another few pages, appellate courts have issued mandamus or ordered dismissal post-sentencing in the following cases. Appellate courts have issued mandamus or ordered dismissals under Rule 48A following guilty pleas in the following cases. District courts have ordered dismissals post-sentencing in the following cases. District courts have granted Rule 48A motions despite guilty pleas in multiple similar cases for similar reasons. United States versus Duncan, order granting unopposed motion to withdraw the defendant's guilty plea and to dismiss the information. Vacating plea of Arthur Anderson, executive, convinced by prosecutors his innocent conduct was criminal. United States versus Calgar. Vacating plea of Enron broadband executive, likewise bludgeoned into a guilty plea for conduct that was not criminal. Now, some of you are probably shouting at yourselves, as you should be, but Michael Flynn's conduct was criminal. He admitted himself that it was criminal. He lied to the FBI, he admitted it, lying to the FBI is criminal, therefore his case is distinguished from those two that we just saw. Well, there is some argument about that. The Department of Justice, in its motion to dismiss the charges, in fact said that it's not clear that Michael Flynn did in fact lie. He provided equivocal answers to certain questions, and it's not clear that he did lie. The DOJ then goes on to say that even if he did lie, it was not about anything material, and it was almost like he was set up in the first place. And why do they say that he might have been set up in the first place? Well, it's based on very hard evidence that only came to light after his guilty plea. And we will get to those facts shortly because Michael Flynn pounds hard on those facts, but first, the following. In short, no authority exists from any court that would allow the court to deny dismissal here. It should have been done upon review of the government's motion, exhibits, and General Flynn's consent. No appellate court has ever affirmed the denial of a Rule 48A motion to dismiss, and there is not a shred of basis to do so here. For this court to require additional briefing or any subsequent proceeding is clear error on this record. All it has accomplished is degradation of the court itself, needless and counterproductive delay, waste of scarce government resources, and dramatic increase of cost to the defendant. Then we get into the issue of perjury, which you may recall Judge Sullivan asked the amicus to look into whether or not Michael Flynn should be held in contempt of court for perjury. Perjury because Michael Flynn is now proclaiming his innocence where he had previously admitted under oath to his guilt. I don't know if that is a catch-22, if that's Orwellian, if that is Kafkaesque. One thing is for certain,
it is messed up.
Any suggestion of, quote, perjury is spurious. Moving to withdraw a guilty plea and asserting actual innocence on advice of non-conflicted counsel does not constitute contempt or perjury. Allegations of such are baseless and spurious. And just as this court did with its suggestion of, quote, treason and, quote, sold your country out, it fueled the media and public outrage against General Flynn when it suggested, quote, contempt for perjury. From the reports of the Inspector General, evidence that has recently been declassified, and the stunning disclosures of Brady material from the independent review by U.S. Attorney Jensen, it is apparent that crucial facts were withheld from General Flynn in violation of Brady, and wrongful pressure was applied to coerce his plea of guilty. We now know of the apparent and material conflict of interest that was affecting Flynn's previous counsel. We now know that the FBI had threatened to investigate Flynn's son if he failed to plead guilty. And we now know from recently disclosed text messages between FBI agents that they basically sat Flynn down in order to get him to lie so that they could either get him fired or prosecute him. But wait!
There's more! Hang on to your seat, baby, cause this one's a screamer!
Rule 11D expressly gives a defendant a right to move to withdraw a plea. As such, withdrawing a plea cannot be contemptuous conduct as a matter of law. If it were, then there would be at least 500 people in the National Registry of Exonerations who would be guilty of perjury. This is an issue that transcends demographics. This court's suggestion that perjury through contempt could lie for someone seeking to withdraw a guilty plea upon exoneration would have a shocking, chilling effect on the rightful future exoneration of wrongly accused defendants who are being punished for crimes they did not commit. The only bad faith in this case occurred when it was investigated and brought, largely attributable to the, quote, entirety of the lame duck USIC with partisan axes to grind. We saw this quote in the introductory paragraph, and where does it come from? This is yet another remarkable Brady violation only recently discovered and not previously briefed. More recently disclosed evidence to show the degree to which the investigation into Flynn was motivated by bad faith. And this is something that attorney Robert Barnes has mentioned multiple times in previous live streams. Regrettably, our, quote, justice system has become a conviction machine so powerful that innocent people are regularly compelled to, quote, confess guilt they do not have and plead to crimes they did not commit. The prosecutor-dictated plea bargain system, by creating such inordinate pressures to enter into plea bargains, appears to have led a significant number of defendants to plead guilty to crimes they never actually committed. Jed S. Rakoff, Why Innocent People Plead Guilty, The New York Review of Books, November 20, 2014. And now it is time for Flynn to pound on the facts. The prior prosecution team misled this court. The extraordinary exculpatory evidence has come to light over the last 18 months, all of which establishes violations of government protocols, policies, and sometimes laws by the government's agents themselves. Example 1 includes devastating text messages the defense recently found that were never produced to it by the government. These are perhaps the most damning messages of the purely political motivation for the investigation and prosecution of General Flynn, and evince another egregious Brady violation. Stroke and Page discuss in their own private messaging their recognition that, quote, the the entirety of the lame duck USIC, United States Intelligence Community, has, quote, partisan axis to grind. Stroke relayed Bill Priestap's discomfort, quote, with the outcome of MYE Clinton email investigation and concern, quote, with oversharing. In particular, Stroke said Priestap didn't, quote, want Clapper giving Flynn transcripts of calls with Kislyak to Obama, White House, because it was, quote, all political, just shows our hand and potentially makes enemies. It is all of this new evidence that compelled the government to move to dismiss with prejudice. These striking documents cannot be ignored. Legal translation: Gleason the amicus didn't just ignore this evidence, he utterly failed to produce it to court. Flynn then goes on to produce an utterly eviscerating 5 pages of bullet points from the Inspector General's report. I'm not going to go through all of them, I'm just going to screenshot them so you can read them on your own leisure, but they are utterly devastating. But let's just go over the last bullet for one example of such misconduct. As FBI agents collectively brainstormed ways to charge Flynn under the impotent and unconstitutional Logan Act, Lisa Page reached out to Peter Strzok and other FBI personnel asking, Page, could the admonition re 1001 be given at the beginning of the interview? Or does it have to come following a statement which agents believe to be false? It seems to be if the former, then it would be an easy way to just casually slip that in. Of course, as you know, sir, federal law makes it a crime too. FBI reply, if I remember correctly, you can say it at any time. However, the agents deliberately chose not to even mention Section 1001, much less actually warn him. In fact, according to Comey himself, they just sent the agents to the White House without telling him anything. This is in addition to deliberately violating protocol to avoid White House counsel and DOJ. In law, you cannot ignore the facts forever, and if you just sweep them under the rug, eventually you're going to trip over them, and I just made that up, and that is genius. And in their conclusion, Flynn's attorneys go into a relatively lengthy quote from a federal court judge, and when we get to the footnote, you're going to know exactly why they're doing it. A federal judge once wrote, a prosecutor can do justice by the simple act of going back into court and agreeing that justice should be done. It is easy to be a tough prosecutor. Prosecutors are almost never criticized for being aggressive or for fighting hard to obtain the maximum sentence, or for saying, quote, there's nothing we can do about an excessive sentence after all avenues of judicial relief have been exhausted. Doing justice can be much harder. It takes time and involves work, including careful consideration of the circumstances of particular crimes, defendants, and victims, and often the relevant events occurred in the distant past. It requires a willingness to make hard decisions, including some that will be criticized. And why would Flynn's attorneys be citing this federal court judge? Well, obviously for the principle of law set out in the citation, but there's another reason. Let's go to the footnote and check it out. United States versus Holloway. Judge John Gleason applauding U.S. Attorney Loretta Lynch for moving to vacate 2 counts of 3 counts against a defendant who had stolen 3 cars at gunpoint and received an extreme sentence. In law, there are few things more gratifying than using someone else's words in the past against them in the present, and there are few things more devastating than when someone else does it to you. For these reasons, and those stated in our other briefs, the only lawful action this court can take is to dismiss the case with prejudice on the government's motion and vacate the plea. There never should have been so much as an investigation, much less an assassination by the political prosecution of General Flynn, a distinguished patriot of 33 years of exemplary service in total devotion to this country. And I've got to say, when I initially started on this Michael Flynn vlog journey, I had absolutely no understanding of the situation. I thought I understood the situation, but I actually didn't even know what I didn't know to know that I didn't understand the situation. I thought it was black and white, cut and dry. Flynn pleaded guilty, therefore he must be guilty, but I have discovered through my research and vlogging on the subject that this is in fact nothing more than an assassination through political prosecution as described by Flynn's attorneys. That is not bias, that is my conclusion after thoughtful analysis of pretty much all of the evidence, at least all of the evidence I think is out there for analysis. And whether or not you share my opinion, I hope at the very least that you now have a better understanding to justify your own opinion on the subject. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section. It feeds the algorithm and helps my channel grow. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, PayPal, Patreon, Subscribe Store, whatever, but nothing helps more than sharing my channel with someone who you think might like it. But more important than all of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.